Yeah, hi, Ray, can you hear me?
Hi, yeah, I can. Hi.
Brilliant, brilliant, brilliant. How are you doing?
Hey, yeah, good, thanks. Yeah, yourself?
Yep. So we're just waiting for people to join
Yeah.
in, chime in,
Yep.
including speakers. It's a huge list, I would say.
Okay, awesome.
Yeah,
Sweet. Is it
yeah.
Abivadan? Sorry, just trying to Abivahan, or sorry, I just want to pronounce your name properly.
Well, the first one was more accurate, Abhivardhan.
Abivadan.
So
Okay, nice.
yeah,
Got it. I got it
makes
first
sense.
time. Okay, awesome.
No, yeah, no worries, no worries, no worries. So I think we have sent the links in case there would be any issues. We'll figure it out. But I think you should start in 5 to 10 minutes at max. It just depends on the speakers because the audience will keep coming in. I think that's the
Yeah,
way it is.
yeah, yeah.
Great, great. Hi Nupur. Good noon. Can you hear me? Yeah, I think. Oh wow, Sankalp is also there. Great, great, great. Just let's
Everyone, good afternoon.
Yep. Good afternoon. Good afternoon. Just so, first of all, uh, good afternoon, everyone from India, maybe good morning from Europe, and maybe otherwise. So, my good name is Abhivardhan. I lead a forum called the Indian Society of AI and Law. It's an industry forum which actually has a legal touch because we are perhaps the only forum at the moment which is led by lawyers or legal people. And we emphasize on the ethics of AI for sure, but with a largely Indian and Asian touch, with a very unique background, to be fair. And we do these committee sessions frequently under the Policy Innovation Committee. Today, I think our chair Ayush Chandra would have joined. Very nice fellow, very talented, but he just was affected with illness, like one of our speakers was, unfortunately. So, well, why this discussion today? Why are we having it today? And what's the reason? So, it's because of one of the speakers who could not join us, Kevin from Modulus AI. And he started a discussion about the definitive feature of how AI is to be defined. Now, that's a very interesting legislative discussion because when we define something like AI or any technology in law, the larger definitive features are, you know, understood from an angle of how do you control or regulate something. And I think that prompted a discussion on LinkedIn between Alexander and Gray. And I was like, you know what? If this could be a build up for a larger and better discussion, let's just take it forward. So from that, it started. We were planning a more of a podcast, but then I was like, I think this could be helpful for the larger committee as well. So we went ahead with this. And in that regard, of course, we have some amazing panelists at the moment. Some of them will be joining hopefully in a while. Uh, so let me introduce all of the speakers who are present as well as who would be potentially joining because again there could be communication issues and other issues which we are not aware of. So to begin with, of course, we have Sankalp Srivastava. He is somebody who specializes in legal schematics and informatics, somebody who explains how knowledge graphs can be used in legal operations management. And he also uses infographics and such interesting tools to explain things in law, which of course becomes difficult for so many people, right? Because legal ideas are crazy by definition. So that's Sankalp. We have Alexander. He comes from Europe. So Alexander is a technology and AI governance legal advisor, and yeah, definitely. So you can also connect with Sankalp. Uh, so Alexander is also somebody who is deeply interested in AI risks and connected issues around how AI regulation becomes interesting. In that regard, of course, we have an interesting speaker with us, that is Ray. Uh, so Raymond is actually also from a coding and technology background and a legal background, so that's a great combination. He is somebody who is, I would say, a very responsible person on LinkedIn when it comes to AI governance, because he actually shares and interesting posts and insights on what's happening. Like, I see a barrage of posts on EU AI Act all the time, but among the haystack, I think Raymond and others, uh, you know, uh, shine out. So yeah, we're happy to have you. I think Raymond, you're from Australia, if I'm right. But yeah,
Yeah, that's right. Yeah, thank you.
yeah. So glad to have you. We have some other speakers as well, apart from the chair of the session, that is Nupur Shah. So Nupur Shah belongs to the Policy Innovation Committee on behalf of Ayush Chandra, since he's not available today. But yeah, the speakers who would be also joining at the moment would be, of course, Sam Pathak, who is from Coop Simplify. He's from a technology background. Dr. Hoda Al Khzaimi. She is also from a technology background, but also understands international relations. But she's very well equipped with aspects related to AI, compute, and the larger economics of AI. So let's see how her insights add up in this. She understands AI ethics and regulation pretty well. She has been involved in the G20 and other international forums. So her involvement would be highly appreciated. Apart from that, of course, Kevin could have joined, who's the CEO of Modulus AI. He's pretty well in AI risk, but nevertheless, we hope that he would recover soon. So let's uh, let's do some context setting for the moment, right? Like, why did this discussion happen on LinkedIn, and why should we have a session on it in the first place? So let me begin with Alexander, since he kind of quote tweeted and he kind of made more context to what Kevin was trying to say. So, Alexander, for the sake of introduction, let us say, for the audience also and also for us to discuss, uh, what was the definitive aspect of artificial intelligence which Kevin was trying to talk about, and what do you think about it? Like, if you can give a outline, that would be great. Maybe even take 5 minutes, howsoever. Yeah.
Sure. So I started my journey with understanding how AI works in 2015. As a lawyer, I mean, because this was the start of my master's in Edinburgh, which was specifically in innovation technology and the law. And the interesting thing was that we exactly considered first from a technical perspective what do technical people mean by AI, right? So we had this course, which was titled Regulation of Autonomous Systems. Of course, in 2015, there was no regulation of autonomous systems. And there were largely academic discussions, but they were very fruitful. As you now see, after less than 10 years, they have materialized into actual law. So I was very happy to jump on this train among the very first. So, and after having considered what technical people understand by AI, we were also thinking about what is then meaningful for policy and regulation, because it doesn't mean necessarily that however technical people define AI for their purposes will be useful for lawyers, for policymakers, for politicians who adopt laws, and for the society at large. And this is the crux of the discussion. We don't necessarily need to adhere to a particular technical definition for the purposes of regulation, because what technical people are interested in is being clear about what they are talking about when they are, for example, setting requirements for particular kind of systems or expecting them to behave in a certain way. And for this, in order to discern one entity from the other, one machine from the other, you need to understand what is the determining factor, right? From the policy perspective, it's not necessarily meaningful to use the same characteristics. So basically, from the perspective of managing risk as well, it might not be necessarily important to discern all the technical characteristics of the certain type of system. It may not be even necessary to discern different kinds of system. It will be important from the purposes of regulation, for the purposes of regulation, to understand whether, from a risk perspective, from policy perspective, there are some differences or some systems, and in particular AI systems, as they are understood in the technical circles. And there seem to be differences in terms of the systems which are used to automate previously all human decision making, and they are employed especially at a large scale, meaning they are really accelerating the decision making processes and subjecting a considerable number of people at the same time to those processes. So if you can imagine, like maybe some legacy process where a certain official or company representative would perform a certain process which would affect, let's say, 10 people in a day, right? So using AI, an advanced system of some kind, which scales, is such, important, legally relevant decision-making may affect maybe tens of thousands of people per day. You see, so this is the main aspect of the newer systems, which was not maybe as relevant before. That when the robots were used in factories, for example, it was not as important because this is a constrained environment, and machines are designed, especially with all this legacy story of safety features and safety requirements which are there, and they are operated in restricted environments. And this is not so important. It was not important to have a dedicated regulation for this kind of system. It was just quite enough to have a general product safety regulation in place, and that would be fine, right? But now there are areas where machines are increasingly used in less restricted environments. They are used to automate decision making at large scale, and the decision making which affect millions of people. This is why there was a need to come up with some additional provisions which would ensure that safety and health and human rights are kept protected, as they usually always were. You see, so this is the main background idea, like why do we need regulation? And then, based on that, there are different stories and different ideas of what do we need to regulate really. So, and there was a huge discussion initially when the European Commission were coming up with the first draft of the UI Act, some people were just arguing, let's just regulate all software. It doesn't matter if it's AI or not. And an argument could be made in that regard because we have a story where the software industry was usually and still is to a large extent exempt from the usual quality requirements, usual quality expectations, which are always there. We are talking about physical products, right? So they're usually exempt. There were usually reasons for that, good reasons to stimulate new industry, which may no longer be the case. So there were people who were saying, let's just regulate all software. Let's just make, or at least let's try to make a definition of what we mean by AI as broad as possible, so that basically everything would fall under it, and then that would be fine. So that would be one way to do things. The others were arguing that no, let's narrow the definition down pretty much to machine learning, because arguably we have a long history of good old-fashioned AI being used in the sense of rule-based systems, which are created by experts based on expert knowledge, more or less predictable in terms of their outputs, right? Deterministic systems. So if you set rules properly, they deliver the same result always under the same, given the same input, they always deliver the same output, which is not the case for modern machine learning predictive systems. It's often not the case. So the people were saying, yeah, let's just restrict this to pure machine learning, because this is where the risks are primarily. So there were these two groups, like they both had arguments in their favor, but at least as far as the European regulation goes, what we ended up with in terms of the final version is we basically now have quite a broad definition, and Kevin was referring in his post to the possibility that, for example, a classic thermostat would fall under the definition which was devised in the end. And this is where we had this discussion, right? So because maybe it was not supposed that a classic non-AI thermostat would fall under the definition of AI system in the React. But the thing is, if you look carefully, I mean, the definition is very complex in the React, and you have to be very careful about each word which you use there. And I myself must admit that I was not among the first to realize, for example, that you need really to pay attention to this small word inference, or as it's used in the definition, it's used in the form of the verb infer, right? So, but the characteristic, feature is inference, which is expected as a feature of something which you would call an AI system under the React. So this is how we ended up, with a very interesting definition. So you can read it up if you have not yet done so. But apart from all the usual elements which were present also, in technical textbooks, like the system is machine-based, the system is, operating in such a way that it follows certain objectives or goals, right? It obtains some inputs, And then it infers based on those inputs how to generate outputs, and those outputs affect the environment. So these are the the basic features which need to be there for you to consider something in a system. And like the main thing is with inference is that how do you define it, and the recitals to the act they give certain indications in this regard. This is where the classic thermostat fails to fall under the definition because this word inference, because classic thermostat does not infer anything. It's not as complicated, although a modern one with some technology inside, some advanced technology inside, may quite well do inference. But the thing is, even though this definition still remains very broad, the thing is like with the UAC, it doesn't really matter. It's not a problem that the definition is broad, because then in the text of the act, then you see further and define what is meaningful for the regulation, what needs to be regulated, because not all AI systems, after they are defined as such, are then regulated. Only certain kinds of systems, and this would mean that notably those that are considered high risk, those that are considered requiring transparency during operation, right? So these are the main focus. And in addition to those systems, of course, in the latest version, in the advanced stages of discussions, new provisions were added which relate to general purpose AI models in addition. So, but this is a different discussion. So this is how I would describe the situation.
Yeah, I think that's quite elaborate, and I think it's good to begin with. So we also welcome Mr. Rajesh Sharma. He's from our advisory council. He's somebody who has been in the semiconductor industry and very well known in that. He's also a legal professional. So we thought, wherever he would like to intervene, he can ask some questions or add something. We also have Mr. Sunil Jose. So sir is also from Kerala. He's a very well-known and renowned practitioner property law. He also joined our advisory council just this week. So just happy to have him. Whenever would you like to intervene, it's up to you. So yeah, much glad to have. So what I think we should do forward in this is that, of course, this is a good introduction, and I will let Ray add something on this because he's been a part of the discussion, and then maybe Sankalp can chime in. The one thing which I think we can steer this discussion forward, which was also the purpose in the beginning, is that while we will discuss the thermostat problem a bit and like the basic definitive feature, of course, that includes certain definitions like intended purpose or general purpose or something like that. I think maybe we can also strike some basic comparisons of different legislations which have been there. Now, of course, there's Singapore, there's the US, there's China, there are, of course, the European Union is there. And since there is no Indian perspective yet, of course, I think Raymond and Alexander might be aware that I also kind of drafted a bill which is AIAct.in, just for the sake of public feedback, so we can also discuss maybe some definitive features of that Indian bill. Also, I can also do that. So I think that way we can take up the discussion forward. But to add further, so forth. Ray, what's your view per se on this? What do you think?
On the view on the definition of AI, or just global approaches to AI regulation?
Actually, both, but I think you can steer more towards the definitive factors first. I think once you do that, then after Sankalp's intervention, we'll go with the global. Yeah.
Sure. Yeah. Well, yeah. Want to say thanks for the elaborate overview by Alexander. Just want to say it's really good to be on the same call together with everyone here, and yeah, it's really good to learn from each other. So, I think look, the definition of AI is often the go-to sort of point that many commentators like to look at because it's like the most accessible sort of point to look at. But I often think it's the last thing to focus on. A lot of things need to be considered first that then inform what will be an appropriate definition for AI. So for example, taking the EU Act example, as Alexander rightly pointed out, even if the AI system incidentally overcaptures the entire software market, you still have those risk tier sort of definitions that qualify what is actually going to be regulated and what is not. So that's an example of where reading the definition by itself is meaningless. You have to read it in context of the operative clause. And this is like the fundamental thing with any sort of statutory drafting or contract drafting. So in that context, the definition of AI, it's really, as long as it captures like just what people know by common sense say, yeah, that is AI, then the definition of the EA Act does its job. There may be certain arguments in the niche sort of use cases, like the automated decision making, particularly like from an Australian perspective. In Australia, a few years ago, the Australian government implemented a program called RoboDebt, which is basically an algorithm that matches your income data to your debt data, and it tries to compare that data to see if you've been overpaid in government benefits. If yes, then you have to pay a debt back to the government. That wasn't AI, that was just the database matching algorithm. But if you actually compare that against the EU Act definition of AI system, you could make the argument that actually this is an AI system. But you can also make the argument that no, it is not an AI system because it's not making any inferences. And it's the latter case which can be quite contentious, because if you have a system that does a lot of automated decision making and it's not captured under the AI system definition of the AI Act, then the operative provisions won't come in to sort of cover that. So that's where I can see that niche edge case being a particular interesting angle to look at. But for other countries, right, every country has their own different approach to AI definition, but their particular approach is not so much defined by what the market thinks AI is. It's more predominantly defined by the existing legal system and also what existing laws cover the ground and whether there is a need for an AI specific law. So countries like Australia, UK, Singapore, they're in a similar boat because they're fundamentally common law systems. And in the common law system, very different from the EU, European Union, which is a civil law system, common law systems don't need to have very long, comprehensive legislation. Because our system also can rely on the courts, judgments, and cases to help supplement the law. So in that case, generally in common law system, and also India is similar, there's no real urgency, or this is not the first go-to choice to think about statutory law as a way to regulate something. You often have to look at, okay, what's the existing law? Would it be privacy, IP, consumer protection law? And also, what is the current common law body? So I know in the common law systems, there's tort law, which covers negligence and also covers product liability. And that's also one very big difference between civil law systems and common law systems. Product liability in civil law systems often codified in law, whereas in common law is not really codified. Product liability is more a combination of tort law and also other sort of like contract law principles. And that's a huge point. That's often the overlooked point, because the EU AI Act, its substance is really a derivative of product liability principles that we've already seen in the EU. And a lot of the sort of the thinking and the thought leadership in the EU Act is really built on product liability sort of thinking in the EU, whereas that thinking wouldn't necessarily work in other common law systems. So So that's kind of like that covers UK, Australia, India, Singapore. In the US and China, this is where we see a lot of different things. So starting with China, China's civil law system, but unlike the EU, their system is very top-down approach. It's and also it's a single jurisdiction, whereas the EU is like a collection of like 27 or 26 member states, right? So they've got that separate negotiation process. In China, it's more about some central economic policy that then drives legislative agenda down the chain. And often the legislative agenda is driven by the regulators instead of like the equivalent of the parliament. The Congress equivalent in China doesn't really, it's not like in the EU where they have like a law and then everyone just kind of works upon it. It's more like they got a economic agenda and then the regulators and try to implement that economic agenda through their own sort of jurisdiction. And it's only until where they see gaps between the regulators, that's where the central government then wraps around with their laws. So in China, right, China's already got AI laws. Their AI laws are application specific. They regulate recommendation algorithms. They regulate deep synthesis technology, which broadly covers your deep fake generators, and also generative AI applications. Now, in that particular system where you're regulating by application, the definition is the most important thing because you have to really define a particular use case, a particular application. So their definitions is most important. In that scenario, yeah, you need a lot of industry input to kind of work out, okay, what is regulated, what is not. And their laws are enforced currently by the internet safety regulator called the Cyberspace Administration. And so a lot of the enforcement sort of practice is really rooted in how China currently enforces internet safety. And if you see the theme, China's way of regulating AI is very much a way of regulating misinformation. That's their key concern with AI. Unlike in compared to the EU, where it's more of a broader human rights sort of perspective, in China is more about misinformation. Now, the US is very complicated. The US is a federal system. They've got states and you've got the federal. So by definition already, the constitution already limits a lot what the federal government can do and also limits what the state governments can do. The federal government of America can't regulate every aspect of AI due to the division of powers. So what I've done so far is, first of all, it's very messy because a lot of states are doing their own thing. The reason there's been starting to have some sort of similarities. The biggest milestone was, last year when President Biden issued the executive order that required a bunch of existing federal agencies to implement their own AI initiatives. So in that sense, the US is very similar to China, where it's regulator driven. But recently, a lot of bills have been pushed out, and a lot of these bills they're like pushed. There's like one new one every month, and they're proposed by both the Republican side and the Democratic side. They're mostly focused on deepfakes because a lot of American perception of AI is really focused on the negative impacts of deepfakes. And you also have to consider right now, the US is going through an election year. Deepfakes is often the big sort of hot item in an election year. It's a similar case in India when you were having your election earlier this year. There was a lot of talk around misinformation and deepfake regulation. So the US is kind of going through that. US has a lot of also because of their position in the AI industry, a lot of their approaches are tackling AI for a national security and from a national competitiveness perspective. I recently made a post on the concept of AI nationalism, which is a pretty new term to describe where countries are focused on protectionist policies to bolster the AI industry, often at the cost of other nations. We've seen that a lot in US and China. One big example is when the US is banning exports of semiconductor chips to China. So a lot of American AI regulation that we see right now is really on the AI nationalism side rather than human rights sort of protection legislation. Although there are some that are going around, but with US bills, not many actually become law. They just get passed out often due to political sort of, they want to some certain, it's pretty common for politicians to just propose a bill so that they can be seen as being proactive in this space, even if the bill doesn't get passed. So so basically overall, like that's kind of like what I'm the main markets. I've yet to mention Africa market, Middle East, and Latin America. But you can kind of fit them into the civil law version or the common law version. You can kind of fit them into those buckets, and that helps you kind of predict what is the approach to AI regulation. Yeah.
Yeah, yeah, that's actually a great addition overall. Like I think even this is an observation I have that for China, it's a very top-down information security approach, and also a value-based approach where they think that, of course, for example, you talked about algorithmic recommendation services, if I'm terming it correctly. They literally focus on a very specific approach on this because of ownership considerations also around, the kind of algorithmic techniques which evolve among companies and government bodies if necessary, of course, in China, and of course the data part. So I think that's the ownership mentality also which is involved in China, which is very interesting. Um, so I think, yeah, before I also add something on this, because if I may add some Indian perspective, I might share the screen just for the sake of reference. I think that would be a good talking point because the bill which I drafted also was from a common law perspective. So I think that would be fun to see. Um, Sankalp, would you like to add through something? I think, of course, we would have your introductory
Yeah,
intervention. So, yeah. Yeah.
just a few points that I had in mind. I think all of the previous speakers have spoken brilliantly about the necessary aspects of their local regimes. Since I've worked majorly so far on the legal ontologies as a way to sort of build an expert system for representation and uh, versioning of laws and other logic-based inferences using AI. So I'm trying to understand this using, like, if you use the legal rule ML documentation, I've understood that one of the things is that firstly, there has to be, like, in terms of the broadness and the narrowness of the definition that we started with, it's that there has to be like some sort of hierarchy if we start thinking of this in terms of codified manners. And if we think of it in terms of common law mechanisms, then we need to leave room for uh, what like jurists call discretion and space for interpretation. So I think that's one of the places where I think even linguists have agreed with their interpretation of laws in a logical inferences that this is something that's called defeasibility in the ontological language, and then there's specificity and also general legal concepts that we've all studied in law school tend to apply here because it's common law, civil law jurisdictions that are really I mean, developing these in their own way. And if you look at our local context, I mean, there is significant, I mean, if you study it closely enough, you will understand that our like our regional sort of experience with the cyberspace legislation has been sort of like UN Citral model law that inspired the IT Act, right? So it has always been governed by a sort of commodity-based uh, uh, framework, right? So, like, if there was a UN Citral law on arbitration, we would then change our laws. So either that or our laws would then come up through public consultations and in response to events that we've seen happen with AI. Also, I think Abhivardhan would probably speak about that as well. Uh, but I think what I really wanted to say was about the fact that if you see this historical trend in our legislation and enforcement in the local context, what really comes down to it is that how do we really build the system of governance for AI systems, right? It's not just enforcement we're talking about. It's about the systems that are built in a way that, in the bureaucratic field, there are already so many lacunae with record keeping, with data protection, with sort of collection of the data in ethical manner. That all of that together, if it adds up to a pile of problems, AI will then create a smoke screen in front of all of it by making it such that the automated processing uh, removes the liability from these already existent problems. So if we are going to use AI systems, if we are going to regulate AI systems and even use them for any such of the methods that we've seen here, like subsidy delivering and public policy use cases, then we need to be sure that, from the ground up, we have checked all our boxes about where the errors could occur. Because as time passes, I think what I've noticed is that uh, with austerity measures and a lot of other neoliberalist advances, we are going to we might just witness another smoke screen in front of what's actually happening, and then it ends up happening behind the scenes in obfuscated languages and code, and like in terms of like you know international diplomatic arrangements that are not transparent. Uh, Things like that might affect a country such as ours with a vulnerable population and marginalized communities in a very detrimental manner, especially since we're seeing AI to be a revolutionary tool. So, how do we define AI? And then, if that is a question, definition wise, I think my opinion was that keeping it broad, sufficiently broad to not just cover inference and generation of output, but also, as Ray said, beginning with the the sufficiently covering all the domains that that are there in the AI field. So what I was thinking of was domains such as data analysis, like such as uncovering of latent information, and not just restricting it to generation of outputs, right? Because it's not always that the output is generated; it's that it can be funneled into a pipeline. And then we've seen how the Microsoft kind of vulnerability was also an AI generated kind of workflow that led to a system worldwide outage, but that wasn't output per se, and that's where our definitions are going to have a challenge. Yeah, I think that's something we ought to discuss about how we can cover all of these things, and I think we're going to need to have a global coalition with the global South and see how we can cover all of our vulnerabilities in a specific manner.
Yeah, and that's actually a fascinating point as well to add, I think. So, totally agreed on this. I think in the larger global south, the one issue which could be potentially seen is that, well, I call the Indo-Pacific and the global south both. That's my position. But I just like that term. I mean, Asia Pacific is such a boring term. But that's my personal opinion. Of course, not the opinion of ISAIL. But in the larger Asia or Indo-Pacific and the global south, I think the one thing which interests me is that in countries, not just India, even in the African side and some parts of West Asia, if it could be an issue, or maybe in some parts of Southeast Asia, we could see a problem that, of course, certain economic aspects affect the future of work in a very different way as opposed to how it is being seen in developed countries. Maybe in, what's happening in the US is not the same, maybe because of maybe certain skill issues, right? Like we don't know about the skill capacity. So, of course, certain labor law issues might arise or certain skill issues might arise, not directly, but indirectly. That's just my stipulated view on just what, of course, Sankalp said. I think maybe that requires itself, like the future of work impact, a different session altogether. But I think it's a good topic. I think we can think around it, how it affects, international labor ethics understandings. Like if you are using substandard AI or short-term AI use cases, which might be commercially viable for a time, but not technically viable, and could affect the market in a very different way, then how does it affect it? But again, it's still a very nascent question to begin with. But I think since what Sankalp has raised, yes, it affects vulnerable groups also in the Indo-Pacific and Global South. So I thought, let me just add on that. Okay, so I think what I understand is that we are at a stage right now where we can discuss some other legislations and things. So since Ray has added his points, Alexander has added his points, and of course Sankalp has intervened. Um, Before I may ask Nupur to share her questions if she has as a chair, I would like to share my screen and discuss a bit about the definitive features which I have tried to do with the AI Act. Maybe Ray, Alexander, you know, we can also discuss a bit of it once I share the screen. I think that could be a great addition since, of course, Ray is absolutely right. Like the India has common laws, common law system. So of course that's covered. But the reason I came up with this legislation was more of intuitively seeing how the common law thinking in India, which is also again a lot of things are in India when it comes to laws are still not settled, right? So for example, in the technology side, when we define technology, the Constitution of India does not have a restriction on which government exactly, which is to say, federal government or the union government, and the state government, which are regional governments or union territory and local governments, who exactly cover technology. Although not necessary in India, but from an Indian experience, which is it is interesting because certain sectors are within certain governments, right? So, for example, the Uttar Pradesh and Telangana regional governments in India, they actually could have a sector-specific AI policies and maybe certain guidelines, if not laws. So, how does that change things? So, of course, I'll get to that, but sticking to the definitions point which we are for the session, let me quickly share the screen. Um, and meanwhile, yes, I've just got a confirmation. I think one of the speakers is joining shortly. There must have been some special reasons, so that is clear to me as of now. So, you know, yeah, just would like to confirm. Anyone can confirm me, Ray or Alexander. Can you see my screen per se? Like, is it visible? Yeah, should be. Yeah, yeah. So, uh, so if it's visible, I think hopefully. Uh, Let me show something. So this is what I call the AI Act.in, because the idea was that in India it's still a nascent AI ecosystem. We did not have any idea as to what's happening. There were some policy reports, industry reports, but they were very vague about it. So we came up with this draft, and uh, I kind of drafted it, and we are currently at version 3. Version 4 will come in November. So here's a definition of AI technology. We say. So I've kind of drafted in a way as it could be given a definition, although it's a basic definition, which is like an information system that employs computational, statistical, or machine learning techniques to give certain inputs. Now, kind of, I have uh, taken a limited, a very specific, let us say subjective definition, not that too much elaborate, but of course, section 3 is interesting because from there, it's a whole new classification system, which is very interesting. So that itself creates a very interesting situation. So this is an initial definition, of course. That of course it is. But when we go to section 3, before that, of course, I'll show one more definition which might interest. Of course, there are basic definitions like who is an end user, basic things. We have done it in a more Indian welfare-ish setup, of course, the drafting. Uh, uh, this is an interesting definition, which is what is inherent purpose or technical purpose and intended purpose. So that means that, of course, the underlying technical objective for which any AI technology is designed or developed and deployed, per se, we have used these 3 terms. And that, of course, there are certain specific tasks and functions. Now, that is something which we have done from a perspective of common law, because when you go for adjudication or dispute resolution, or maybe basic approach there where, some regulatory guidelines could come which are not that binding but very self-regulatory, the potential could be that in India people at least can map out in a legal sense as to, okay, what could be a jurisprudential approach to this, how can we have better adjudication on this. So I kind of drafted in that way. That was the intent there, and I'll show you a bit upon the technical purpose part where it is interesting. I don't know how people would take it. We actually have received some very colorful feedback on this for sure, especially from the technology people in India. So there are certain definitions directly inspired by the DPDPA, like the significant data fiduciary or SSD from the Digital Competition Act, which again, hypothetically, we are assuming is under force. It's not under force. So that's there. Then there are certain basic definitions, partly inspired by the EU AI Act, but of course, uh, it's a bit of a change. Now, the one thing where the testing data definition is interesting is, of course, about confirming the expected performance of the AI technology before its placing per se. Now, the expected performance is something which could be a ground, but again, that depends. Now, this is something which again is a thing which we are still yet to change, because we are not having a regulatory understanding based on weights of a neural network. I think Raymond will agree, and Alexander might agree that weights of a neural network do not mean anything. They just are a quantitative estimate. But while they might work with companies like OpenAI for a limited reason, I don't think largely they have a purpose. But again, I'm open if anyone disagrees with on that. And these are just some inferences that I classified on the four parts. One is a conceptual method, which is the idea was that if we do not have a very close-ended definition of AI, instead what can we do is a very substantive law approach can be taken, because that works in common law jurisdiction, where whether it is IP disputes, consumer law, criminal liability, corporate veil, whatever, corporate governance, we can say, you know what, okay, you can have a conceptual understanding, and that conceptual understanding is subject to jurisprudence. But there could be certain guidance understanding which could be given through some definitive principles. So section 3, from where section 4 comes and all, it's more like a guideline approach, not like an exactly binding approach, but like a substantive approach that, okay, you want to have certain substantive principles which work for adjudication and basic loose end understanding, but still within the common law uh, aspect. I think that can be a bit distributed and understood with. So that was the approach there. The second is, of course, technical method. It's kind of similar. Of course, all the speakers may relate with this. Kind of similar to the European legislation and what is the general perception across legal understandings across the globe. So we have taken with that, but with our own understanding that, of course, there are multiple short-term and unclear use cases. Of course, there's a wholesome definition for it. What does it mean? What are the parameters that's there? I might not discuss that in detail right now, but of course, that's there. I mean, maybe we can all discuss later on this. But then, of course, there's a specific purpose AI application, which is again interesting because it's a technical understanding. So that gives a lot of adjudicatory space for us also to think through. It's more like a guideline approach here, not exactly like a top-down approach literally, but it's just an experimental way to say, okay, fine, it could work in courts or it could work. That's an Indian understanding. To move quickly forward, this is a commercial understanding. So like Raymond rightly pointed out, and I think Alexander also pointed out, in common law countries, of course, we don't have very clear product safety regulations directly on. It's always a mixture of civil liability, tortious liability, and all that. So it's again a guide. It's a definition. It's a keyhold approach, but not that very acerbic where the definition itself is too restrictive. In fact, we have added one more definition in commercial method. We call it AI for preview. And the idea with that was that, OpenAI and all these companies, they come up with preview-based AI applications, right? Now that interestingly creates an interesting scenario where you say, okay, it's not commercially a product. It's still in a research state. You're still charging for the subscription. So what exactly could be a better quantum to define? So these are more like, we can also say ad hoc definitions or ad hoc classifications per se, which could be useful for certain sectors or commercial law reasons or certain interpretive reasons in IP or contract law in general, like general terms. So that was the larger reason. And this is something which is again contested. It is contentious, which is risk-centric method. There is a partial inspiration from the European legislation here, but I think this is the only part which is very very largely inspired by the EU AI Act. So that's of course there, and a larger elaboration is this, that it's an issue-to-issue concept classification, which is based on if there's a case-by-case basis. Again, so it's a guideline-based definition. It's not exactly a binding definition. Ethics-based is more. There are illustrations also, like it used to be in common law legislations. In ethics-based, for example, if you see, it's also about sector and sectors neutral context and all that. So it's an attempt. Of course, I can't share everything in this right now. It's a time issue. But of course, once I've shared the screen, of course, I was thinking to have Raymond's comments, Alexander's comments on this for sure. So let's have that quickly, and then maybe because Dr. Hoda will be joining in a short while, so I think she will also add insights, and then maybe I think if elaboration would be necessary on definitive features, we can do that. So, Raymond, what do you think of the initial definitions in this draft bill? Again, this is just a private bill, just a proposition, but what are your initial thoughts? Yeah.
Yeah, this is a pretty impressive and nuanced taxonomy. So just purely based from looking at definitions and seeing how the nuances in scope and differentiations across different dimensions. For example, I saw if you had like by certain purpose, by certain techniques, and etc. Like this is a very good toolkit for anyone out there who's whether you're writing a contract or whether you're writing a policy or a law, to have that sort of list of possible definitions to use would be very good. Obviously, as I said before, like it's the operative provisions that are also important. So yeah, like just if it's just purely just to have like a sort of like a resource or just to set out all the possible definitions I could use, then yeah, I think this is a good base. Definitely keen to see what sort of operative provisions you use to enliven all of this. Yeah.
Yeah, totally agreed on the operative side of things, actually. Um, Alexander, what do you think about what I've shared, the definitions and certain parts? Like, what do you think about the structure, from a common law angle? So, yeah.
I'm sorry, my connection is not very good, and I don't see anything which you are displaying. I'm just hearing, so I cannot comment.
All right. I think we can connect later. I can share you the link. That's all right. Um, but maybe I think I was so sorry for the cough. Uh, maybe Sankalp can add a bit on this uh, until, of course, Dr. Hoda joins in a short while. But I think maybe we can influence more into the global AI legislations, maybe a bit tiny understanding on how it happens in Singapore and how it's a different person. But Sankalp, what do you think of the definitions per se? General.
So one of the things I think is it's traditionally a problem with all legal systems. I think when we try to come up with a response to an innovation, it's we can't start off just by like on a blank slate, and that's going to be a huge problem with something as expansive as AI. When you said there's the consumer, I think the point above this where it was the consumer-based classification, or I think there were the product, service, and there was a general purpose one at the end. So in those cases, we will have to look at how these products, services, and infrastructure, and even things like platforms are defined in every jurisdiction that we want the AI Act to be operative to. In this case, it's India. So we have a diverse set of state jurisdictions as well, interpretations. So to begin with, I think India or someone like if we're trying to if we're trying to build a legislation, we need to have a lot of like background, what they call in international law, the trova preparatory. I think that's the preparatory documents and in each of the commissions when they come up with a new issue. Then even though the law itself is not that hard and fast, or like strong law in the sense of like applicability, uh, once you notice how the bureaucratic procedure is, you will notice that it is very representative, and it has a lot of consultation and thoughtful consideration put into it. I'm not saying that we are not doing that. It's just that everyone across the globe is now in a race to regulate AI, and for good reasons too. But like let's just step back and see where we're starting from with AI. And if we're going to start as if it's a new technology, that's not entirely true, because I mean, Alexander's been working on this since 2015, and this has been the concept itself was introduced by John McCarthy in the 50s. So we need to look at how what the base is for this, and build up from there. And how do we build up? It's through the, I guess, I'm not very, I'm not saying this is the only way, but what I would suggest that we all do is collectively document each of our countries' interlinkages with AI as a technology. So for example, in India, we have the Consumer Protection Act, which has gone through so many amendments that now there are e-commerce rules. And then we have product liability rules that were introduced in 2019. Similarly, IT Act now is going to turn into something. Probably there's been so many amendments as well, but we don't really know what's going to happen to the already present legislation. So this will need a lot of documentation so that when it comes before an adjudicating authority or a decision-making authority or even an in-house department which has to look at, what decision do I make about this compliance? It doesn't seem like it's a new thing. It's not dropped out of nowhere. So there are, I really appreciate the fact that you've covered so many things that if I had to introduce AI to a lawyer, I would point him through this. And that's where I think the lawyers will probably struggle with is, I mean, the same thing that I'm struggling with is that, I mean, we all have our own things, but my biggest issue with all of the legislation so far has been that they act as if it's the newest introduction in the cyberspace regarding it, and I think we can do better than that in terms of interlinkages, in terms of version histories, in terms of providing the context itself for every term. So uh, that's one of the things I think in terms of consumer classification also has many ramifications for stakeholders because we're not just looking at legal stakeholders or lawyers. We're in fact looking at entire industries who are going to be using AI in so many diverse ways that we're going to have to look at how we can carefully consider each concern. I think the United States Treasury did that internationally and came up with a set of guidelines. And the Biden administration also came out with sort of risk-based criteria. So I think it's always going to be a question of our bureaucratic capabilities to enact a law.
On and thank you so much for your comments on this, Raymond and Sankalp. To quickly add on what Sankalp said, that was actually the intent, that if a legislation is to be thought out in India or any other country, because India's unique situation is it's such a big country which has 28 states, 26 states, and a lot of union territories, 8 union territories, if I'm right. I might be wrong on the number, but 20 plus. The thing which we also see, which is not exactly a European problem, different jurisdictions and all, although it's a unified approach in EU. What we see in India also interestingly is that we share the experiences of diverse industrial policies to AI and in future, of course, other technologies. Although to be fair, the reason we say diverse so I think we all came across, if we are on LinkedIn, we all came across, the Singapore Supreme Court coming up with definitive practices as to what could be followed by, court officers when it comes to using generative AI tools. And that's a fairly interesting approach on ability, which gives a lot of inferences on how our. Just to ask quickly to Raymond and Alexander. Raymond, would you like to add something on what Sankalp stated on definitive aspects per se? Before we move on, maybe specifically.
No. In the interest of moving along, maybe just
sure.
Happy to move on to the next section. Yeah.
Absolutely. So let's do that because I think probably Dr. Hoda will be adding her views from a perspective of West Asian countries like UAE and others. So in that interest, maybe let's get more specific on, how it happens in the common law countries. And you have specifically discussed China. We can get back to China. when of course, in common law countries, there's a lot of similar approaches which are coming up on regulating AI, quote unquote. Like in Australia, of course, they came up with responsible AI guidelines. Then again, in the coming weeks, something else came in, and these things keep coming up. Do you see any? So this is, of course, a specific question to you to begin with. Do you see any larger differences in the common law countries as to how uh, similar they are on understanding AI per se, and these definitions like intended purpose and other things? Or do you see any striking differences and similarities? I think we can discuss that also. That would be great to add, and I think maybe Alexander can chime in. Maybe, yeah.
Yeah, that's a very good question. I think so. I already mentioned product liability as one example of like one of the key differences between the civil and common law. And you already mentioned that when you were going through your draft, so I won't mention that again. I think the other big area of difference is the approach to common law. Sorry, the approach to contracts. In common law systems, contract law is like 90% built on court precedents and how businesses have approached contracting. In common law systems, we very rarely have mandatory contract clauses. Unlike in civil law systems, where for example, in the EU, you have the GDPR, which mandates certain mandatory clauses for data transfers. In China, you have a lot of mandatory contract clauses. So in common law systems, mandatory contract clauses is something that we don't really entertain unless it's super necessary, for example, in the consumer law context. But that has been a very big thing because a lot of AI regulations, not just about regulating development, but also regulating procurement. And a lot of civil law systems tend to have some rules around how you should interact with a vendor, what clauses you need to like implement to whenever you want to procure an AI system. In common law systems, we don't really have that philosophy. It's more like, okay, whatever is the common law rule around contracts, that then defines market practice, and then market practice would then kind of sort itself out. So I think that's the biggest difference. It's like when you read the laws, it's like I think this is one of the things that's hard to appreciate unless you're actually in the market, because if you're just looking at a common law statute and a civil law statute and you're just comparing word for word the language, there's going to be a lot of similarities in terms of how things are defined and operative divisions. It's the enforcement mechanisms that are really different, but it's really hard to understand enforcement if you actually don't know the system or you haven't been in the system. So I think that's the main one. So product liability and contracting practices.
Before I would ask Alexander to chime in on this, I think this is true because even at this moment, for example, in India, there have been discussions about guidelines, or let us say circulars and regulations. One, there's a whole discourse about regulating deep synthesis, which is deep fakes or synthetic content in general, plus deep fakes. And again, whenever a guideline is proposed or something is proposed, they are still subject to those principles of civil and public law, because the civil and public law principles are very hazy on those regards, because again, it's an interpretive issue. On contractual clauses, interestingly, of course, our arbitration system is still evolving and we have tried efforts, but beyond the dispute resolution also, I think beyond the dispute resolution clauses and court enforced mediations, which has been tried a lot in India. So one thing which is interesting is about how these contractual clauses might become interesting in the media and entertainment side. So it is not something common in India, but like you said, from a market practice angle, it becomes very interesting because at least in media entertainment law, the IP clauses regarding AI, that's actually becoming an important issue. For example, a few singers and actors in India, they actually, artists basically, they basically filed cases through IP lawyers, and they said that our content should not be processed through AI we have, or in India this new concept has come up of personality rights. But I believe it's more of a privacy and autonomy consideration which is commercialized. You can say that openly instead of merely saying personality, but that's okay. That's just maybe an indirect subjective way of doing. But the one case which I found interesting was the Arijit Singh case, because in that case specifically, it was more detailed by the specific High Court in India and Mumbai, where they were like interested to say that yes, AI generated content which is emanating out of something which is original of such a person, of anyone, that needs to be taken into adjudicatory concerns as to, should you process it or not. Generally, yes, of course. If it is commercial enough, of course, there are concerns. You know it very well. Companies, unions, they come up with statements on, their AI generated content should not be permissible when it comes to anything publicly available or commercially available or howsoever. So that is a very interesting jurisprudential development I thought I should point out, since you mentioned about contractual clauses and the potential of that, because that was there. But yeah, uh, Alexander, what would you like to add on this, on similarizations of, or differences in common law jurisdictions, or maybe further? Because I think after this, we can maybe try to go more on China and West Asia. So that way we can do, I think, or maybe you can add more on the European context, maybe also in the context of how Council of Europe does, because it's a human rights-based intergovernmental body, unlike the European Union, which is a more political body. So I just thought if you would like to.
Yeah, sure. So I can speak about the Council of Europe a little bit, what they were doing, and basically, when we are thinking about the European EU AI Act, right? So usually there is a lot of interest, specifically from companies, which in the end will be the main targets of this regulation, which will have to comply with it to the extent they develop or deploy, the systems which fall under the act. And as I said, not all systems fall under it, just a mere portion. But anyway, usually there is a lot of interest from the private sector, right? So, and there is no such great interest to the instrument of the Council of Europe, and it is understandable because, for one thing, the Council of Europe is, addressing its conventions primarily to governments, to nation states, and although companies, natural persons, they can rely on the provisions of the conventions to the extent their country has ratified a convention. It's not something you think from, it's not the first thing you think about if you're a company, right? So, but yeah, it's important to state, that basically in September in Vilnius, the first member states and countries which are not member states of the Council of Europe too have signed the first global, binding legal instrument on AI regulation, basically, because up until that point, all we had were recommendations and similar stuff. So nothing binding was in place before September this year. So there was a UNESCO instrument, of course, but again, these are all things. It's all good, but it's not binding, not mandatory. And now we have a change. And now, even mind you, the United States have signed. I'm not sure they will be able to ratify it. It's another question. This treaty, but they have signed the treaty, and many other countries have signed, and we have a potential to have this really high participation rate in this first global treaty. which goes beyond Europe in terms of participation, which was, created in the Council of Europe. So, and I used to be, working at the Council of Europe during the preparatory stage, where we were preparing, basically doing the preparatory work before the negotiation started. So I was not participating in the negotiating the agreement text, but previous to that, I was participating and giving some, analysis related to, what could be regulated and to what extent and so on. And it's I think it's good that we have this instrument. It's good that binding. It could be much wider in scope as it ended up, as opposed to how it ended up being, because basically each country can decide to what extent it can either directly apply the provisions of the convention to the private sector, or just decide to implement similar provisions, but not directly apply the provisions of the convention to the private sector. So it's a difference, and many people, especially from civil society organizations, not happy about it, not happy at all. There was a lot of discussion on the internet, on social media, about why did we end up with such a convention, and maybe why there are other exemptions. But other exemptions are also quite traditional for the Council of Europe, like excluding the national defense or national security, from the scope, which is also the case for the EU Act, for example. But it's quite natural. It's nothing new, so nobody should be really surprised about this. There are still some useful provisions for nation states to implement on their national level in their national law, based on the commitments they have undertaken by signing, hopefully, then ratifying, and they will ratify, hopefully, the provisions of the convention, which says a lot about what should be the ground rules for using AI systems, primarily in the public sector, but not only. But nevertheless, so it's quite aligned with. It could not be otherwise with what the EU Act provides. It's just that basically how this works. This works is basically the EU Act is considered an implementing instrument on the EU level for the EU countries. So this is the means for them to implement already the provisions of the convention, right? So this is how how it works. Yeah. So obviously, I mean, there is a lot of criticism, as I said, with regard to the scope, to exemptions, but still, it's a good step forward from mere recommendations to actual hard international law that we now have, and which spans beyond Europe. And hopefully we will see some ratifications coming up.
Great. To add on this, of course, on the first global AI treaty, which is interesting. The Council of Europe's approach kind of reminds me of my discussions with Gregor Strojan. So Mr. Gregor Strojan is somebody who is working at Deloitte right now, at Deloitte specifically legal, in Estonia. He was the co-chair and also the chair of certain AI committees, yeah, or ad hoc AI committees, which were responsible on the larger AI regulatory or AI ethics understandings in within the organization of COE. So even in discussions with him and Maxim Karlik, who's also part of our advisory council, he also kind of referred to similar discussions on the definitive features of AI because uh, both of them told me, and I have podcast recordings, of course, I can share them maybe on LinkedIn. So even in the discussions with them, we came across on the rights-based approach which is being implemented now. Uh, what the Council of Europe's approach reminds me of is basically the UNESCO recommendation on AI ethics and how definitively they are shaping up the rights-based approaches. A similar trend I also saw in the digital economy working group of the BRICS G20 presidency. So I think it's of course I think there will be criticism. I also think kind of that of course it may be an international AI treaty for sure, but uh, again maybe on from a guideline basis it might be great, but again as a rights-based treaty, what are the trickle-down effects we are expecting legally? I think that is yet to be seen. That's just my limited criticism at the moment because again it's very sector specific also. So that's also interesting to see through. Moving forward, let's move on to China and West Asia, like how AI is defined, how certain specifics around AI are defined. Now, Raymond can correct me. I'll get back to Raymond, but before going on China, I think maybe 2-3 minutes I can have Sankalp's intervention on what Alexander and Raymond said. I'll just give a quick in context. If I'm right, if I'm correct, Raymond, I think China has 4 laws. 3 of them are in enforcement. The fourth one, which is on generative AI, maybe it is not an enforcement or it might be enforced. I think you can correct me on that. Uh,
Yeah.
yeah,
So in terms of like hard laws, and when I say hard laws, I mean like laws produced by the legislature. There's really only 3 main ones, which is already mentioned before. There are a lot of standards that China is writing and producing, and these standards, many of them are still in draft mode, still under consultation, and it depends on who the regulator is. Some are drafted by the telco regulator, some are drafted by the internet safety regulator, some are drafted by the data protection regulator. So I think China's gone to the point where the central sort of overarching legislation is kind of done. They're now moving into more prescriptive standards. So that's where they get at. But the thing about China's situation is that, and it's not just for AI, but just tech regulation generally, China's approach to regulating tech is really rooted in a combination of competition law and data protection law. And I can talk about this a bit later, but like just the history of how China has approached big tech regulators. If it's not about privacy issues, then it's about competition, and it's more around the latter, competition law, how they treat and enforce laws against like monopoly structures, oligopoly structures, and the enforcement practice is not consistent. It has changed a lot over the few decades. It's really rooted in the economic growth and performance. During times of high economic growth, it tends to be pretty relaxed, but during times of like I guess less growth, or where there's a clear market instability risk from a certain big tech provider, that's where they go really hard. So that's kind of the context that I've observed in China.
yeah. That's actually a very interesting take because, uh, yeah, I think they kind of uh, mix and mesh around their larger competition policy concerns and data and information security concerns. That is something which is pretty apparent. But yeah, I think they're liberalizing on those measures, and that's something which is interesting to watch out for. Uh, of course, what has always interested me about also from a commercial law angle is how they define these services. like certain things are service aspects, certain things might be productized, but I think that is something which I've been kind of looking forward to when it comes to any guidelines and you know regulating understandings which have been coming up. So I think we'll add up on China. We also have Dr. Hoda with us. So, Dr. Hoda, if you would like to add something on West Asia, maybe Sankalp's intervention can come a bit later. Uh, you know, please feel free to. We are happy to have you. But yeah, please. Okay. Okay, I think there must be some logistic issues. Uh, we can have Doctor's Hoda's intervention later. But Sankalp, while on steering through more on the parallels between China and Europe, as you see, as you've heard from both Raymond and Alexander on this, I'll add on China a bit later. Maybe Nupur has some questions also, maybe, hopefully. So Sankalp, maybe you can take maybe 5 minutes. I think okay. I think Dr. Hoda may be in a position to speak. Yeah. Uh, so yeah. Hi, Dr. Hoda. Can you hear us? All right. I think uh, we'll have the intervention later. So Sankalp, I think for now you
Yeah.
can of course
Okay.
look at the parallels. I think that would be interesting to know from you specifically. So yeah.
Yeah. So yeah, I just want to sum up what my thoughts are. Basically, what I'm hearing is that uh, the EU has its own AI Act, and we're seeing civil law jurisdictions take the lead. But what exactly I think would have helped every jurisdiction in this regard would have been sort of consensus, and we're seeing that uh, the UN has a lot of pertinent issues to deal with. So I think the leadership aspect has to come through collaboration, at least for now. And I'm not really sure if I can say where the parallels will be because, uh, as we have noticed, each country has its own regime, and it's not merely about civil and common laws. It's about the fact that in a country like India, again, I'm just like this is the regime I'm more contextually aware of. So something which starts with legislation has to come through, like it has to like if you look at the IT Act in India, like it had provided for an appellate authority, an adjudicating authority, and if you look at the number of cases that go to the appellate authority, there have been barely 100 cases over the last 20-25 years. I mean, that's the statistics I last checked a couple of years ago. So that's not promising because what we then know is that uh, India is not really bothered about the cyberspace except for certain, like the government uses it for its own benefit in not necessarily transparent ways, which makes it difficult for countries like us to really adopt a stance on a technology so useful such as AI and possibly something which can be revolutionary in many ways. But we need to see that how the absence of any regulation is now something that only the government can make up for, and we're not really sure if that will be done transparently. So how can the like I mean cyberspace traditionally? I mean, if you look at how the the discussion topics have been, it's been like you know uh, deployment and development have always been the key considerations for AI. So deployment happens in a staggered manner. Resources itself is something that uh, should have required some sort of consensus, but it's leading to detrimental environmental impacts. So all of these things, if they have to happen, I think we need to make sure that there are standards for this. Now, standards, as someone said, the Council of Standards. I'm very sorry, I forgot the name, but like this has been something that's been a pertinent issue. Standards, when they come up for any purpose, uh, the technical literature on it is accessible only to the people with the resources to hire the human resources, and then in that case, AI's equitable nature loses out. So I think we need to make sure that while we're developing standards at any internationally relevant organization, that there is a lot of like open access material available in terms of like what led to that contextual term, so that people like good fit practitioners like people at ISAIL and everyone else here, I mean like in India and the global south, we can make sure that we're doing something that you know that our formal systems are not necessarily entirely capable of because of the bureaucratic, economic, and we might even say political hurdles at this point.
Right. That's an interesting point added. Um, and I appreciate that. Uh, Dr. Hoda, if possible, you can try to unmute yourself. I think it would
Yes,
be.
I can do it now. Thank you so
Yeah.
much, Abhivardan.
Yeah.
So I would like to say that we discussed last time that it's an effort that requires a stack level kind of work. And it's not just an effort of, as the previous speaker who spoke about the fact that the AI effort in China is an effort of wavering against competition and against the global industrial competition. When it comes on the effect of addressing the impact of AI legislation on the global south, it's important to consider the unique challenges and opportunities that are presented by AI in these regions. And for that, we need a centric database of all of these kind of indigenous issues that we are trying to solve for. Because we know that as of 2024, only 49% of the nations in the global south have legal enforceable framework of AI for data protection, for example, and other aspects. But massively, if there is any kind of aspects when it comes to AI legislation, the first focus is about data protection frameworks. So compared to 83% in a global north, this type of disparity highlights that we need a robust AI policies that can foster economic growth while ensuring ethical use of AI technologies. And our policies, as we have discussed last time, and I think this is something quite positive, has a tendency to understand the power and importance of bringing together a risk-based plus value-based and principle-based kind of framework. Of course, we are understanding the potential of AI in advancing progress in critical domains such as agriculture, healthcare, education, which quite particular and relevant to the fabric of growing essential core industries in Global South. Um, I think we need to fix the stack. We have a stack issue and stack problem. So we need to establish, for example, a robust data protection technologies, data protection policies and legislations. Also, we need to establish a stronger industries when it comes to building AI software, AI accelerators, AI hardwares, the semiconductor kind of as well foundation is very important. Therefore, I think it's very pertaining and important for Global South to invest in local researchers and local R&Ds that would integrate not just quite advanced skills and research skills and analytical skills on training and building AI capability across different governance structures. I'm talking about having those kind of R&Ds in universities, having them in industrial platforms, and as well global kind of governmental frameworks. Governmental organization is very important. I think we face historical development issues. For instance, AI tools that have been adopted over the past decade to tackle traditional development issues and with diverse use cases among the member countries and global south, especially in sectors that are directly affecting the livelihood of people, and the population of people are quite scarce. And I think we need to reanalyze that and get to understand what would be our deployment priorities across global south. And having, again, a transparent, open source, open platforms, not just for scientists, but also for policymakers, researchers, and industry developers is very important. I would say in conclusion, it's very, very important that we look beyond the current AI systems versus control systems that we have. And the current EU AI Act, which is considered a global landmark when it comes to governance structure within AI, but also look at the possibilities of building beyond general purpose AI foundational models. Because if we follow the general purpose models here and we forget about every type of other industry that AI could contribute to building, then we forget the priorities that we have to develop for, I would say, critical technologies that needs to exist around this whole wider ecosystem. I would leave it to that unless you have a very specific question for me, Api Vardan. I'll be more than happy to answer your questions.
Sure, I would appreciate that. And I think the context that you have put up here is actually quite good, because to add on that, when we look at definitions or definitive understandings, even in the larger West Asian area, from UAE to others and beyond, because of course, and even in general, what you have mentioned about general purpose AI and the rush to make definitions, I think there's a lot to appreciate about and agree with. So that's definitely out there, because before we could have your presence, of course, we were discussing about the AI bill a bit, and Raymond and Sankalp were adding their comments. And I appreciated the part where they said, and even that was the intent, that the bill is a hybridized approach for common law country like India, where we give them a piecemeal point at this stage so that they classify AI in a more flexible way. Because as Raymond mentioned, a lot is about, in common law countries, what happens, for example, in India, a lot is more about these uh, flexible adjudicatory measures. So to be very
And I think
yeah,
Abu
please.
Vardan, just onto your very important points about bills. I think if we scan the global kind of scan, if you looked at the OECD and their kind of AI campus that they have developed, we know that 600 global bills have been established. 40 only of them has been enacted into laws. So bills are very great kind of indicators of interest, indicators of significant legislative interest of a specific technology, and in this particular scenario, it's AI. However, how can we move from just losing over 70% of the efforts that are developed on global AI bills into actual enacted law? I think building that structural analysis where people understand the power of every phase is very important, because it will get them together to understand when their effort is very critical and important to build the ultimate framework. So because we are not just interested in legal classification framework or in just pushing for a bill that will not be seen through at the end of the cycle. But by optimizing this effort and making sure that it gets to legislation, and this legislation at the end of the day is not going to be crippling to innovation, but will be adaptive, it would be agile, it would be sensitive to risks as well to values, to human and ethical values. So it's quite a struggle at the moment, I would say, globally, not just in global south on these terms.
Yeah, that's actually, these are very interesting points. And I think these strategic documents like bills, which might not see the end of, they might not see light at the end of the day, I think they give a lot of insight, of course. To add on that, I think what is an observation I had with uh, countries in Middle East and West Asia. I think maybe Ray can add also more on this with his perspectives. Uh, is that one thing which we see is that again in countries like UAE and others, they are not focusing on very explicit definitions of AI at this moment. It is whether it is Kuwait, Oman, Jordan, any other country. They're not specifically focusing on definitions of AI. They're more focusing on the welfare side of things or maybe the development side of things, which to say that okay, uh, let us more look at the ad hoc purpose here as to what it can deliver, and from an industry angle, how it could, in a hybridized way, benefit. I think that's what my all understanding as well has been. Uh, but Raymond, based on what Dr. Hoda just remarked, uh, would be happy if you'd like to add on this. Maybe I think we have necessarily you have very perfectly emphasized on China as well. We have discussed China in detail. Maybe I think a session on China and larger Asian regulations can be done later. But I think you have done you have emphasized, but on West Asia, on what Dr. Hoda's insights are. What do you think? Yeah.
Yeah, I'm trying. There's a lot of ground to cover. So I'm just trying to think of just one point. um, I think honestly, it's very hard to meaningfully compare, AI definitions across countries. As I said earlier, you can have all the legislative texts out there, compare them word for word, and try find differences like that. But as I said, it's the real comparisons in the enforcement mechanism. But that said, if we really want to compare definitions, I think a much better use case would be how countries define deep fakes. Because I think that's a very interesting subject area. With deep fakes, you could either define it as, AI generated fake videos or images. So that's like a very traditional perception of deep fakes. Or you can go broader and you capture anything that is synthetically manipulated or edited, irrespective of AI or not. And so, like as I mentioned earlier, there are a bunch of deep fake bills in the US. There's like 6 or 7 of them flying around. Some of them are deep fake specific, like only about AI generated deep fakes. Some are around synthetic content generation, and others are not really focused on deep fakes or synthetic content generation, but just around using person's voice and face for some other commercial purpose. So I think that's I think that's a much more defined use case that you can then compare a lot of acts around the world. So, like, for example, they're approaching this whole topic through something called deep synthesis technology, which I mentioned before. So they're focused on the synthetic aspect of deepfakes rather than just talking about deepfakes itself. I know this is also an interesting area where some countries, instead of focusing on deepfakes, they're focusing on misinformation generally. So like regulation around misinformation. Now that's a more tricky issue because this only works if the law allows for regulation of speech, basically. In California recently, there was a bill that recently passed for. It's a bill to regulate use of deepfakes for election misinformation. That's basically what the bill did. It got challenged in the California court for being unconstitutional and in breach of the first free speech amendment. Recently, the court actually agreed. It's not been fully finalized, but they allowed for the case to proceed, and they allowed for an injunction of the California state to not enforce that law for the time being. So I think, yeah, deepfake, misinformation, synthetic content, I think that's a much more interesting definition comparison. Yeah, that's the only point I wanted to make.
Yeah, and I totally agree with you on the misinformation regulation point. That the same issue is kind of happening here, and I will definitely have Dr. Hoda's intervention. I think we have 7 minutes left, so I don't know if we would be able to take questions, but yeah. Uh, Nupur, you can confirm me on chat, maybe on WhatsApp per se, if you have any questions per se. But yeah, Dr. Hoda, you can have your quick intervention. Yeah.
I like the example that Dr. Ray gave on definitions and how intricate definitions might seems a little bit contradictory on few bills that would be passed. I think also AI safety is another kind of aspects that is a bit controversial because some AI kind of features would enable you to work on hallucination structures, while in reality it would also encourage unreliable data to be produced, and in some sense, this unreliable data could also be contributed to, I would say, fake news. And there has been a bill as well that last, I think, June um, was attempted to be passed in the US that was talking about the fact that companies who will not be able to guarantee safety measures on AI structures, they will be asked to deactivate specific features within the jurisdiction that they're having. And this would be a massive, in my opinion, would lead to a massive technology disconnect and between building for mature technologies across different sector and providing a level of equal governance of this technology across different sectors. So I think we really need to study through uh, the motivation behind this passing through specific bills, because in intent they could have really a great kind of objective, but the outcomes are not supporting to the motivation, to the initial motivation.
Yeah, that's actually a great intervention to add as well. So I think to just quickly outline, because I think we are at the concluding point for this now. Uh, we have very well effectively discussed how similar and different, common law uh, understandings have been in countries from India to Singapore to many others, and even Australia, which Raymond has very well elaborated. We also discussed the AI Act.in bill, at least on the classification and definition side. And I'm glad to receive the feedback also. And of course, it's actually pretty much corresponding to what I received even from the technology stakeholders who could understand basic definitions of AI. So that's I'm grateful about that. We also discussed about uh, the larger ontological and aspects as to how it affects the future of work and groups also. I think Sankalp had his interesting interventions wherever necessary. Alexander also added his points pretty well on the European side of things, especially how the definitive understanding has been. But uh, I completely agree with Ray that of course definitions are not the only way to understand global AI policies and legislations. But I think the purpose of this discussion is, in a more exhausted sense, achieved. If our co-speakers agree that at least we have kind of juggled around and discussed how these basic features have been in an involved sense affecting, you know, uh, the intent to regulate AI or the intent to adjudicate around AI. I think maybe in future, maybe just a suggestion, maybe we can do some sessions around how the contractual practices have emerged or something around IP. But I think that could be decided later. But I think the outcome of this session has been that we actually have in an exhaustive way discussed. But of course, some few concluding remarks would be appreciated, of course, on the experience of our speakers, how it has been for them discussing with others. And before quickly, if Mr. Rajesh Sharma, who's a part of our advisory council, wishes to add quickly on, because he comes from a semiconductor background as well, I thought if he would like to add his interventions or something. I think then we'll just have some concluding remarks, just basic concluding remarks. Then. Yeah.
Yeah, it was very interesting, to get the perspective from different countries and from different geographies. And, understanding from a common law perspective and from an educating perspective. Since, my background is more on the machine side, on the semiconductor side. I believe that, more and more these machine generated things, which may be automatically done, we may not even know that what is coming out, so that machine generated content and, how it can be tamed. Uh, we certainly require the regulations, but at the same time, the creativity cannot be, curtailed, just bringing more and more, regulation in the system, as we saw in EU, Act, that, there are a lot of controls which are there, which are making the AI developers, thinking in the more creative manner. So very good discussion, Ray and, the other uh, presenters, Aleksandr, Sankalp, and you yourself and Dr. Hoda obviously, brings very crisp, summary of the things. So thank you very much. I was glad to be part of this. Thank you.
Certainly. So I think it's a good wrap up, but before we officially wrap up, just a few seconds, let us say. So Raymond, would you like to add something in conclusion? Maybe we could discuss it later. You can suggest that, of course, but anything in conclusion would you like to add? Same for Aleksandr. Maybe Ray can do first, then Aleksandr, then Sankalp. Then,
I just want to say thank you for having me on board, having the opportunity to share my observations. I think the field of AI is not only a big, important technology, but it's also a field that unites a lot of different backgrounds. Technologists, legal, but also linguists. A lot of linguists are now playing a big role in the AI space because they need to help, use words, and a lot of language models, they're built because of linguists have been able to help technologists understand how language works. It's also uniting backgrounds and cultures. It has also highlighted gaps where we need to catch up on. So I feel like the field of AI is more than technology. It's a really big shift in how we do things. And yeah, that's all I wanted to say. Yeah.
appreciated. Aleksandr?
Yeah, I was also happy to join this discussion. Really interesting perspectives, and this reminds me once again that it's very nice to have really a variety of opinions on things and variety of geographies. And this is very useful, and I appreciate very much this opportunity to discuss this topic with you today.
Great. Sankalp?
Thanks everyone, and just want to say I hope we can continue to collaborate because of all of our common interests cross board. So yeah.
Dr. Hoda, just some quick concluding remarks.
Sure, thank you so much. I do agree that this is a quite interdisciplinary kind of line of action that we should put in together. It's very important for us to be on the table as scientists, developers, social scientists, as has been said, legal practitioners, but also anthropologists as well, because we are maybe being at the risk of digital erosion or erosion. If we don't put into act, how can we preserve, the fabrics and the quite unique tendencies that comes from different fields or different nations across the table as well. It's an interesting collaborative framework, and I would like to see the power of the Global South in bringing a unique R&D structure, a unique policy-making structure that are quite interdisciplinary into the map. So hopefully we'll see that happening very soon.
That's great. So first, thank you so much, everyone, for coming for this session. We pulled it off successfully. Some of our speakers, unfortunately, could not join due to health and maybe festive reasons because it's Vijayadashmi right now in India. So we kind of did not realize that the festive dates could have also been a reason. But I think the recording will definitely be out on YouTube, and our viewers and even our well-wishers, as well as people who are in the professional community of law and tech, they actually will find this discussion really wholesome. So thank you, Raymond. Thank you, Aleksandr. Thank you, Dr. Hoda. Thank you, Sankalp. Thank you, Mr. Ajay Sharma. Also, thank you to Mr. Sunil Jose, who joined in the beginning to support our initiative. So that's it for now. We will do more such sessions as usual on the Policy Innovation Committee. And heads up, ISAIL is going to complete its 5 years in November. So there will be some announcements. The AI Act.in will have its fourth version. And yeah, I'll make some announcements as may be necessary at the moment. So thank you so much. I'll be ending the recording, so I would request the speakers on for maybe 5 minutes if possible for feedback reasons. Thank you so much for your intervention. Listening. Thank you so much. You may leave now. Thank you.